We have one.
Judge Casanueva, if Mr. Young could turn on his camera himself, I cannot do that.
Oh, Mr. Young, if you can hear the sound of my voice, you did. Okay.
I've got it all taken care of now, Judge. My
You
apologies.
are far ahead of me, technologically speaking. You're there, you're live, got a great background, and you're clear on your voice. Mr. Rosenblum, are you, does your sound work too? We had a couple problems this morning.
I hope so, Your Honor.
You're there. Okay. We are ready for Tanya Brown and Geico. And counsel, Mr. Rosenblum, I believe you are the counsel for the appellant in this case?
Yes, sir, I am.
Correct. And did you wish to reserve any time?
5 minutes, please, Your Honor.
You have it, sir. And I will do my best to give you a timely warning when you are there so you know when to, whether to keep going and use up your time or to stop.
Thank you. For the record, Your Honor, I'm Louis Rosenblum from Pensacola, and I represent the appellant, Tanya Brown. This is an appeal, as the court knows, from a summary judgment entered against my client in a legal malpractice case against an attorney who works for Geico General Insurance Company. There's no dispute about the three elements of a legal malpractice case. The parties agree. It's number one, the employment of the attorney. Number two, the lawyer's neglect of a reasonable duty. And three, negligence as the proximate cause of the loss. Now, the summary judgment in this case was grounded on the third element, proximate cause, but the parties have briefed all three under the tipsy coachman rule since these points were all raised in the court below. And I will go in the order that I mentioned unless the court directs me elsewhere, which I suspect they will. The first issue, Mrs. Setchell, the lawyer who worked for Geico General, argued that the scope of her representation of Mrs. Brown was limited to assisting with a global settlement. 3 people were injured in the accident and there was limited coverage. And 2, attending her husband, Mr. Brown's examination under oath. And she thus reasons that because her scope was limited, she had no duty to investigate Mrs. Brown's liability, which is at the heart of this case. She was not liable, or at least should not have been liable, because she was not the driver of the vehicle, nor was she an owner of the vehicle. Now, there's expert testimony on both sides. The plaintiff's expert testified that the scope of Ms. Setchell's representation was not limited. And in fact, he testified, and with good authority, that the representation of Mrs. Setchell could not be limited without informed consent by Mrs. Brown, signed by her in writing. There's a Florida Bar Rule 4-1.2C that specifically states that. Ms. Setchell had nothing in writing signed by Mrs. Brown limiting her representation just to the global settlement or the examination under oath of her husband. Now,
but did Ms. Setchell's retention extend to defending the liability action?
No, it did not. And
did Ms. Setchell's representation extend to give her the authority to admit liability?
No, there was no allegation that she defended the lawsuit that was ultimately filed and defended by the late Mr. Crawford.
So you're arguing there's no break in the chain whatsoever when Ms. Setchell's boss refers to the case to a seasoned trial lawyer who's tried over 350 cases, Sid Crawford. You're arguing there's no break in the chain whatsoever of her responsibility when the entire file is given to Sid Crawford and he is expressly directed to review the entire file.
That's our position, Your Honor, and allow me to explain if I could. There are several things that we allege, and they're supported by the record, that Mrs. Brown could have done and should have done. First of all,
You mean Miss Setchell?
Ms. Setchell, I'm sorry.
You said
At
Miss
the
Brown.
I get my Setchels and my Browns.
It's all right.
At the very least, Mrs. Setchell should have told Mrs. Brown, hey, you're not liable for this accident. Now, they might sue you, but you need to know you are not responsible. Now, what Mrs. Setchell would have done with that information, we don't know from the record because it never happened. These are not sophisticated people, the insureds. In fact, Mr. Brown couldn't even read. Mrs. Brown had to read his mail to him. So that's the first thing she could have done, is she could have notified her client. The second thing she could have done is when she got correspondence from Nadine Diaz, who was representing the injured party, Setchell could have easily picked up the phone, and we have testimony from Mr. Larry, our expert to that effect, easily picked up the phone and say, hey, Nadine, did you know that my client, Tanya Brown, was not an owner and was not liable for this accident? And had she done that, it's very likely, we'll never know, that Mrs. Brown never would have been sued and Mr. Crawford never would have been in the position of making the mistake that he made. The other thing she could have done is, you say that it was assigned by her boss. Actually, there's a distinction here. Setchell worked for Geico General. The insurance company who insured the Browns was Geico Indemnity.
So that's
Geico
Mr. Sever. I may have gotten them confused, but that's
no,
Mr.
and I don't think this record really tries to draw the distinction from a legal standpoint. That might be for another case, but Geico Indemnity sent the file, the entire file, as the court said, to Mr. Crawford and included the title certificate, but had Setchell alerted Geico, say, hey, I just attended this examination under oath of Mr. Brown, and by the way, he was the sole owner. Mrs. Brown is not liable. Well, perhaps Geico would have put that information in the assignment letter to Crawford. Crawford's son, Benjamin, testified that when there is an issue of ownership or coverage, the assignment letter typically contains that information. That might have alerted Mr. Crawford. But our best argument, it seems to me, is had Ms. Setchell done her job, Mrs. Brown never would have been sued. I mean,
but what about the fact that Geico sends the file which includes the certificate of title in it? Whose responsibility is that to review that? Mr. Crawford's.
Look, we do not contend that Mr.
So
Crawford.
Isn't that implicitly telling Mr. Crawford she doesn't? I mean, that's what the title says.
Well, remember, Your Honor, we're here on summary judgment. Benjamin Crawford, who was a partner of his late father, testified that the title certificate was in the property damage subpart of the file that Geico forwarded. And when there is no issue of ownership or a property damage claim, and that had been resolved, in such cases, the property damage subpart of the file is going to get less attention than the liability portion.
But did the retention letter to Mr. Crawford from Geico expressly say there is no issue as to ownership of this vehicle?
No, it did not. Didn't even mention it because
Geico
didn't know it.
So you, an experienced trial lawyer on the other side, you probably did some defense work. Maybe you started out there, you do plaintiff's work, whatever. I did defense work. You read the whole file. So Geico didn't say there's no issue concerning ownership.
No. And let me emphasize again, we admit, we acknowledge that Mr. Crawford was negligent. He was negligent in entering into the stipulation. But as we've also pointed out in our brief, there's a difference between an intervening cause and a concurring cause. And an intervening cause it has to be unforeseeable. And that was what the trial court found, that it wasn't foreseeable that Mr. Crawford would make such a mistake. But what the case law says is it's not the specific act of negligence that must be foreseeable, only that harm in general was foreseeable. And so I would submit to the court that while Mrs. Setchell may not have said, oh my goodness, Mr. Crawford, if I'm not careful, might screw up on the ownership, she didn't have a clue about that. She admitted she didn't do anything about it, didn't even realize that that was an issue. But the point is had her negligence in failing to address the ownership and liability, it was foreseeable to her that her client would be harmed in some form or fashion. Maybe she couldn't foresee exactly how, but the law does not require it. And there's Supreme Court precedents to that effect.
So if two different people are in possession of the same information, Ms. Setchell has the EUO where Tanya says, I don't own it. Sid Crawford has the certificate of title that clearly shows that Tanya has no ownership. And the person with the title goes into court, tells the court and also tells the client, you need to admit liability, judge, we're admitting liability and ownership, and et cetera, et cetera. You're saying they're both at fault for this?
Yes. Yes.
They both had equal amount of information, but the person who made the decision that caused the harm seems to be Mr. Crawford.
If Your Honor will recall, the argument is supported by the record that had Mrs. Setchell recognized the liability issue related to ownership, Mrs. Brown never would have been joined in the first place. Her negligence took place before the suit was filed. So that is one distinguishing factor with the court's argument.
But does the interrogatories from the plaintiff specifically asking who owns the vehicle, does that not put Mr. Crawford on notice? And the fact that Miss Brown said it was under a creditor, which should have raised light bulbs, but he changed the answer to them being co-owners?
Your Honor, he was negligent. And whether you want to say he was real negligent or just negligent is not going to change the fact that Mrs. Setchell was negligent too. I mean, she walked out of that examination under oath, and it was Mr. Brown who testified, not Mrs. Brown. And she knew that Mr. Brown was the sole owner. And her notes are in the record. She didn't even make a note of it. It just went right over her head. Now, she subsequently has testified, yeah, I knew all about the dangerous instrumentality doctrine, but to say she wasn't negligent, of course, I don't think anybody can argue that. Now, the causation argument, we submit that that's a jury question. Yes, they have a really good argument. I can hear them pounding the bench before the jury that Mr. Crawford, may his soul rest in peace, was real negligent. But that doesn't take away from the fact that Mrs. Setchell's negligence was likewise a contributing cause. And I haven't mentioned it yet, but we have this fairly recent medical malpractice case from the Supreme Court, the Ruiz case that we've cited at length in our brief, where you had the anesthesiologist screwed up with the preoperative procedures before surgery, and then the patient died because the surgeons alleged negligence. And the anesthesiologist obtained a directed verdict because the third district said, well, the surgeons were the primary cause of the patient's death. And what the Supreme Court held is that if the first doctor, the anesthesiologist, substantially contributed to the patient's death, he may be liable even if the surgeon was the primary cause. And by analogy to this case, even if Mr. Crawford was the primary cause of the $20+ million judgment that was entered against my client, and we've admitted in our reply brief that he was the primary cause, that does not mean that Mrs. Setchell did not substantially contribute to the ultimate loss. And under that Ruiz case, that makes it a jury question as to whether her negligence was not the, but a proximate cause of the damages.
You have 25 seconds left, in case you were wondering.
How much?
25 seconds to get to 15 minutes.
Then I'll go ahead and reserve the balance of my time unless the court has a specific question now.
Okay, counsel, thank you so much. Very well, Mr. Young. Now that we know your technology is working perfectly, you have the floor.
Thank you, Your Honor. May it please the court. Good morning. My name is Richard Young, and I represent Ms. D. Setchell and Geico General Insurance Company. On behalf of Ms. Setchell and Geico General, we ask that the court affirm in all respects the trial court's order granting summary final judgment in favor of Ms. Setchell and Geico. This case arises from an auto accident that occurred on April 26, 2008, in which Patrick Brown injured 3 people while driving his truck. Geico Indemnity Company insured Patrick Brown with an auto policy at the time. That policy provided $10,000 per person, $20,000 per accident liability coverage. Because there were more claimants than there were per person limits, Geico assigned Ms. D. Setchell to set up a global settlement conference to try to split the proceeds between the 3 claimants. Ms. Setchell began representing the Browns and attempting to set up a global settlement conference on May 5th of 2008. Before any global settlement conference could be set up, 2 of the claimants, the Perez's, hired a lawyer and demanded an examination under oath from Patrick Brown. An examination under oath, Your Honors, is basically a deposition before suit's filed. Ms. Setchell attended the examination under oath with both of the Browns. It was at this examination under oath of Patrick Brown that, in response to a question from the Perez's attorney, Mr. Brown said he was the owner of the truck. Tanya Brown did not give an examination under oath and made no statements as to ownership of the truck.
But do you dispute that at some point Miss Setchell learned that Tanya Brown had no ownership interest in the truck before Sid Crawford was retained?
Yes, we don't have any evidence in the record that the plaintiff can point to that Miss Setchell knew that fact. And the fact that Mr. Brown said he was the sole owner of the truck, without putting too fine a point on this, Mr. Rosenblum is asking that Ms. Setchell would rely on a gentleman who can't read the title of the truck to be the end authority on who owned the truck. So having said that, we don't believe that there was any duty that ever arose on Ms. Setchell's part to tell Mr. Crawford, who, as Your Honor pointed out, is a 30-year-plus lawyer with 350 jury trials under his belt before he passed away, to investigate ownership. Following the examination under oath, the Perez's settled their claims for a single $10,000 per person limit, leaving a full $10,000 per person limit for Ms. Dominguez Garcia, the other claimant. Ms. Setchell was in the process of attempting to set up a guardianship because Ms. Garcia was in a coma, and she had enlisted the help of another lawyer when a letter of representation was received by Geico from a lawyer claiming to represent Ms. Dominguez Garcia. Geico immediately tendered the remaining $10,000 per person policy limits to that lawyer to settle Ms. Dominguez Garcia's claim. But that lawyer refused to settle. In fact, Ms. Dominguez Garcia never offered to settle her claim pre-suit, never demanded any information about assets of the Browns or ownership of the truck. Instead, she simply filed a lawsuit. There is absolutely no evidence in the record to support the statement that counsel made on his opening argument that had Nadine Diaz been told that Tanya Brown didn't own the truck, she'd have never sued her. In fact, the open question is whether Nadine Diaz actually already knew that information because of the fact she could have done a title search herself to see who owned the truck. Instead, a lawsuit was filed. When that lawsuit was filed, Geico hired the law offices of Sidney Crawford to defend the Browns. As the court is aware, Mr. Crawford is an extremely experienced lawyer. Geico advised both of the Browns, Ms. Setchell, and Mr. Crawford of this change in counsel. The Browns even signed a letter acknowledging the change in counsel and thanked Ms. Setchell for all her help. It is undisputed that Ms. Setchell's representation of the Browns ended on January the 6th, 2009, when Mr. Crawford was hired to replace her and to defend the lawsuit. At this point, and we believe this is incredibly important, Ms. Setchell had made no representations to Mr. Crawford or to Ms. Dominguez Garcia as to the ownership of the truck, one way or the other. In other words, she had done nothing to set into motion any chain of events. When Geico referred the defense of the lawsuit to Mr. Crawford, Geico sent to Mr. Crawford its entire investigative claim file. Included in those materials was a copy of the title to the truck, which clearly showed that Patrick Brown was the sole owner of the truck. Mr. Crawford, through his billing records, we know, reviewed those file materials, spent 2.5 hours reviewing them before he answered the complaint that had been filed by Ms. Dominguez Garcia. After his thorough review of those materials, he filed an answer on behalf of the Browns in which he denied that Tanya Brown owned the truck. Ms. Dominguez Garcia filed an amended complaint to which Mr. Crawford filed an answer, again denying that Tanya Brown owned the truck. At this point, it is undisputed in the record that had nothing further happened regarding Tanya Brown's position regarding ownership of the truck, no judgment could have been entered against Tanya Brown. Ms. Dominguez Garcia's lawyer could never have proven that Tanya Brown owned the truck or that she had legal liability for her husband's negligent operation of the truck. In fact, Ms. Brown's own retained legal expert, Dennis Larry, agreed with this at trial when he was asked the following questions and gave the following answers. Question, but at the point that he, in brackets Crawford, denies the original allegations, the ball is in Ms. Dominguez Garcia's lawyer's court to now come forward with proof of ownership, isn't it? Answer, correct. Question, and that is something they could not do. Answer, could not do. Question, so if nothing else happens, no admissions are made of ownership from this point forward, no judgment could ever be entered against Ms. Brown, could it? Answer, that's correct. That's at the transcript, page 453, lines 13 to 23. It is clear, Your Honors, at this point that Ms. Setchell had committed no act that set in motion a natural and continuous chain of events that resulted in a judgment being entered against Tanya Brown. To the contrary, at this point, if nothing changed, no judgment could ever be entered against Ms. Brown. Unfortunately for Ms. Brown, things did change. Indeed, what happened next, we believe, under the law, can only be described as a bizarre and highly unusual series of events that we do not believe that Ms. Setchell could ever have reasonably foreseen. After initially denying ownership of the truck on 2 separate occasions, Ms. Brown signed sworn interrogatory answers admitting to ownership of the truck. And as Judge Sleep pointed out, her actual handwritten answer said that Chrysler Financial owned the truck. But someone at Mr. Crawford's office, either through consultation with Ms. Brown or independently, changed that answer and listed her and her husband as co-owners. She signed those under oath. She later gave a deposition in which she again admitted to being a co-owner of the truck. Finally, at the pretrial conference that occurred shortly before trial, Mr. Crawford, on behalf of Ms. Brown, entered into a stipulation in which he admitted that Ms. Brown was a co-owner of the truck and that she was liable for Mr. Brown's negligent operation of the truck. Had this stipulation not occurred, no judgment could have been entered against Ms. Brown because Nadine Diaz, counsel for Ms. Dominguez Garcia, could not have proven ownership of the truck. This undisputed fact was agreed to again by plaintiff's retained expert, Mr. Larry, when he stated, question, then there was an admission of liability. Answer, right. Question, and without that admission of liability, this case had gone to trial without that admission of liability, and Nadine Diaz could not have produced any information, any proof of ownership of Tanya Brown for that truck, there would be no judgment against her, would there? Answer, Nadine could not have proved that Tanya was an owner. That is correct. She had been put to the test. She could not have done it. That's at the transcript, page 45, line 22 to 66. Moreover, Your Honors, this ill-advised stipulation of ownership and liability by Ms. Brown on the advice of her lawyer, Mr. Crawford, could not have reasonably been foreseen by Ms. Setchell. Again, as the plaintiff's own expert, Mr. Larry, agreed. He was asked the following question. Now, we heard your opinions on direct examination, and I thought I heard you say that if Sid Crawford knew that Tanya Brown was not an owner of the truck and did nothing about it, that would not be foreseeable to D. Setchell. Do you recall that? Answer, I think the way I phrased it, if he had this information that D. Setchell had and failed to take any action to correct the parties that are improperly joined, I don't think that would be foreseeable. Again, that's the transcript, page 447 lines 20 through 48. Your Honors, in fact, Mr. Crawford had at least as much information as Ms. Setchell because he had the actual title to the truck in his file, which he said in his billing records he reviewed for 2.5 hours. Your Honors, the undisputed facts reveal that Ms. Setchell did not commit legal malpractice during her brief representation of Ms. Brown. She did not set in motion a chain of events that in natural and continuous sequence led to the entry of a judgment against Ms. Brown. Nothing Ms. Setchell did or did not do could be described as substantially contributing to the entry of the judgment against Ms. Brown either. To the contrary, we believe the undisputed evidence establishes that the sole and proximate cause of the entry of the judgment against Ms. Brown was the stipulation of ownership and liability entered into by Mr. Crawford on Ms. Brown's behalf. That act constituted a superseding and intervening cause that was not reasonably foreseeable to Ms. Setchell and for which she should not be held liable. Based on the undisputed facts of this case, the controlling case law on legal malpractice, foreseeability and proximate cause, as set forth in our brief, the trial court correctly granted summary judgment in favor of Ms. Setchell and Geico General, and we ask that your honors affirm that judgment in all respects. Thank you.
I see no questions. Thank you, Mr. Young. Let me clear the clock. Okay. Mr. Rosenblum, you have your 5 minutes, counsel. I note on my screen you are muted. Still muted. There we go.
I had a technology meltdown.
Welcome to my world.
First of all, the testimony of Mr. Larry that Mr. Young just referenced was clarified at a different page in the record. And what Mr. Larry testified is that if D. Setchell had told Mr. Crawford, we have information that proves she is not the owner and she has no business in this lawsuit, and then Mr. Crawford failed to act, that would not be foreseeable. But that didn't happen. Mrs. Setchell never said that. Just going through my notes, Mr. Young said that Geico Indemnity insured Patrick Brown. He didn't mention, they also insured Tanya Brown. She was a co-insured, and so they owed her a defense as well. Mr. Young also made the statement, there is no evidence that Ms. Setchell knew Mr. Brown was the sole owner. That's an undisputed fact. No one has ever contested the fact that Mr. Brown so testified at the examination under oath. And no, Mr. Brown couldn't read, but his wife, Mrs. Brown, was there. And during the examination under oath, she periodically interjected when Mr. Brown made a mistake, but she didn't say a word when Mr. Brown said, I'm the sole owner of the truck. And I would also mention, I'm not sure whether the record reflects Mrs. Setchell had a copy of the accident report, but it's on the accident report as well that Mr. Brown was the owner of the truck. I want to conclude by just trying to emphasize the point. Yes, Mr. Crawford, late Mr. Crawford, was negligent in entering into the stipulation, but there is evidence for summary judgment purposes. A summary judgment, by the way, let me just note parenthetically, the trial court denied summary judgment initially. It went to trial, which resulted in a mistrial, but during that mistried trial, she denied Geico's and Setchell's motion for directed verdict. It was after the trial that she decided to grant summary judgment. But be that as it may, I want to emphasize this point that there is evidence in the record to support the inference that had Mrs. Setchell done her job, Mrs. Brown would not have been sued. And I'm referring to page 421 of the trial transcript when Mr. Larry was asked, in your opinion, did Ms. Setchell have an obligation to attempt to get a release for only Tanya Brown? And Mr. Larry's answer was to attempt it, yes. I think if she had just gone to the lawyers for the most injured party, that would have been Nadine Diaz, and said, look, I don't know what your plans are to file suit, but whenever you get around to it, if that's what happens, understand that Mrs. Brown is not an owner of this car, this truck, and she shouldn't be sued. Whether Nadine would have given a release or simply taken note of the fact she wasn't an owner should have resulted in her never being named in the suit in the first place. Now, we obviously can't prove that that happened because it didn't happen. And the reason why it didn't happen is Ms. Setchell dropped the ball. And so we respectfully submit that proximate cause and intervening cause are questions of fact, and that this cause should be reversed for a jury trial. Thank you.
Thank you. Thank both counsel for your presentation. You're welcome to exit, and you're our last case, so there's really nothing